Alright, so this is chapter 7, and we'll be talking about computer crimes or cyber crimes. So our agenda is we'll go through checking the different categories of computer crimes, and we'll discuss some specific requirements for crimes, and they are mainly the actus reus and the mens rea. Those are Latin terms. So we'll see that all crimes or most crimes, they are only crimes when those two requirements are met. And then we'll go through the scope of the Fourth Amendment with regards to electronic communications, and also check on some possibility to exclude evidence, illegal evidence mainly. And we'll look into the issues of jurisdiction for computer crimes, and then moving on to the federal statutes related to computer crimes in the US, and we'll end by discussing very briefly the challenges in investigating and prosecuting cyber crimes or computer crimes. So let's look at the different categories of computer crimes, and they are mainly three. But first of all, let's define what a computer crime is. So a computer crime is known to be crimes that involve the use of a computer, and some examples would be sabotage or stealing electronically stored data. So it's a very broad definition actually, because all wrongdoings, all illegal activities through a computer, committed via a computer, will be defined as a computer crime. And those computer crimes are also called cybercrimes, mainly because of the internet. And the categories, and this is important, the categories for computer crimes, they are three. So those categories are related to the computer being the object, the subject, or an instrument. So again, computer crimes are the ones committed using a computer. Hence, the computer may be the object of the crime, such as when a hardware or software is stolen. So the computer itself, the software itself was stolen physically, or even the software could be electronically stolen, and not the computer. So this is when the computer is the object of the crime. And a second category is related to when the computer is a subject of a crime. So those are the crimes that have no analogous traditional crimes. They are only computer crimes. So examples here are spams, viruses. So those are crimes that are specific to the use of computer. So there is no traditional type of crimes in which a computer is the subject. Okay, and there's also hacking, there's ransom, there's several others in which the computer is the subject of a crime. And a third category is the one in which the computer is only an instrument to commit traditional crimes. So identity theft, for example. So you may have your SIN number or or you may have your credit card in your wallet, and then you lose your wallet, and someone will use your personal identity, personal details to commit crimes. So this is in the real world. But here, when we talk about the computer being an instrument to commit this traditional crime, is when your personal information is used to commit crime via the computer. So the computer is used as an instrument. So crime is committed using the computer. But those are traditional crimes. Even before the existence of a computer, those crimes already existed. Those traditional crimes already existed. But now, with a computer, not now, but with a computer as an instrument, they also exist via computer. So this is when a computer is used as an instrument. So those are the three main categories. Again, computer is the object of the crime, so the hardware is stolen, for example, or the computer is the subject of a crime. So those are the pure computer crimes. And then when the computer is an instrument of traditional crimes. So those traditional crimes can take place without a computer, but if they take place via computer, so we say that the computer was an instrument to commit them. Moving on, so we'll look at the two main requirements for crimes, and not only for cyber crimes, but for any types of crimes. And as I said, those are Latin expressions, so the actus reus and the mens rea. And what are they? So the first one, the actus reus, it is the Latin expression for a guilty act. In other words, it is the forbidden act. It is the wrongdoing. It is when you actually act in the wrong way. So for a crime to be committed, when the accused is being prosecuted, the prosecutor will need to prove that the accused actually acted in that way. So let's take, for example, a virus. A crime in which the computer is the subject. So in a virus, a accused to have created a virus, to have spread the virus. So prosecutor will need to prove that this accused was actually the one creating the virus, was the one spreading the virus. So was the one acting wrongfully. This is what the actus reus means. And the mens rea means the guilty mind. So we usually say that the actus reus is the objective part, so the action, the forbidden action, and the mens rea is the subjective part. So it is in the mind of the accused. So in general, most crimes, unless the criminal code or the criminal law prescribes differently, so most crimes, they require the accused to have intention to act wrongfully. Because if you act wrongfully by accident, in principle, the actus reus requirement is met, but the mens rea will not be met. It is not as simple as I'm telling you, because the mens rea, the guilty mind, also has some consequences with regards to being reckless. But still, for us in this course, it is enough to memorize it in a way that the mens rea is related to intention. So again, when we're talking about a virus, a computer crime, prosecutor would need to prove in court that the accused actually was the one creating the virus and spreading the virus, plus the accused had an intention to create the virus and spread the virus, for example, to cause damage to others' computers. Okay, so both the objective, the actus reus, and the subjective, the mens rea, requirements have to be established for each criminal conduct of an accused. Okay, so it means that the job of prosecutor is not an easy one, but that's the way criminal law is, and you may realize that the criminal concepts and requirements they differ a lot from the civil ones, from the private ones, because there isn't the intention aspect in the civil or private field, only in the criminal area. Okay, so those are the two main requirements. There are other requirements or other elements, but those are the main ones for someone to be convicted of a criminal conduct. Moving on, we look at one of the main protections in the U.S. Constitution, the Fourth Amendment. And the Fourth Amendment is related to computer crime, not only computer crime, any types of crimes, but mainly to computer crimes, because the Fourth Amendment will prohibit any unreasonable searches and seizures by the government. In other words, actually, a government needs a warrant that is issued by a judge, by a court, to search and to seize whatever they need to for their investigation, for their prosecution. So this is a protection for citizens, because if police officers or investigators, they do not have such a warrant, they cannot invade, they cannot cause our privacy to be broken. And again, a very strong protection from abuses of the government. The conclusion here is that the Fourth Amendment, and actually based on this case, Katz versus the United States, the conclusion is that based on the Fourth Amendment, the Supreme Court has established that everyone has a reasonable expectation of privacy. So our emails, for example, or nowadays our social media accounts, they cannot be looked upon unless there's a warrant. There's an exception here which is interesting, just for your information. Border officers, they do have the authority to check our phones, so we have to allow border officers, immigration and border officers, to check our phones. So we have to unlock the phone. They can check whatever app we have on our phone. So the recommendation here is that you should keep your social media, your cloud storage logged off, because if they are logged on, they can check anything you store there, anything you have there. But if they are logged off, they cannot, without a warrant, they cannot force you to log on to any app, to any service, to any social media. So this is just a recommendation, if you will. if you don't want to have your privacy invaded while crossing the border. Okay, and the reason here, it seems they have more powers than regular investigators and police officers, because the principle here is that border officers, border immigration officers, they are the first point of protection of a country. So they are the ones who will keep a potential hazard, potential danger out of the country. So that's why it is understood and it is actually regarded, considered by courts, that they have more powers. But still, we do have some protection over them. So this is with regards to the Fourth Amendment. We do have a reasonable expectation of privacy. However, if there's a warrant, then government officials, they can search and seize whatever is relevant, and also they can do this, but within the scope of the warrant. Okay, so if they are searching, they have to substantiate their request for a warrant. A warrant may be granted, but the scope of the search, the scope of the seizure may be narrowed down, may be kept within, will certainly be kept within some boundaries, because a warrant will never give full power, unlimited power for searches and seizures. One exception here, which is important, it's not an exception, it is actually a consequence of government officials not complying with the Fourth Amendment prohibition. So if someone is a victim of a warrantless search and seizure, or just the search, in other words, if there's a search without a warrant, then whatever evidence that is collected, that is obtained in such a search and seizure, they may be excluded from the prosecution, because they were obtained in an illegal way. And it is this has been called or defined as the fruit of the poisonous tree doctrine, which means that the evidence is the fruit in a metaphor way. So the fruit here would be, the fruit seems to be good, but actually because it comes from a poisonous tree, the legal search, then the fruit is also poisoned. So the fruit cannot be used. So the evidence that came from an illegal search cannot be used. So maybe someone committed a crime, there was a search, a warrantless search, evidence was obtained, the accused was arrested, was prosecuted, but the accused may be, I'm not saying the accused will be, but the accused may be not found guilty, may be acquitted, because the evidence that would establish the accused committed the crime was an illegal evidence. So government officials, police officers, investigators, they need to be very careful, and they need to respect the principle established by the Fourth Amendment. Okay, so that's also very important, and not to say interesting as well. So now, looking at some jurisdiction issues for computer crimes, we've dealt with jurisdiction in Chapter 1, and you may remember that jurisdiction is related to the venue, the place, where, what court, what entity has power, has jurisdiction to move forward with prosecution in this case, because we're talking about crimes. So who has jurisdiction? Who has power to either prosecute or to come up with laws, legislation, etc.? So in the US, it is considered, the internet is considered a channel and instrument for interstate commerce. So it is regarded that the federal government and the federal courts, they have jurisdiction over computer crimes. So states in the US, they have power to come up with a criminal law, but specifically for computer crimes or cyber crimes, it is under the jurisdiction, under the power of the federal government. Hence, federal courts will have jurisdiction to prosecute accused of computer crimes. With regards to state court jurisdiction, so there's very few circumstances in which a state prosecutor will be able to prosecute or to lay criminal charges over an accused within the state, because if it is a computer crime, it has to be established that the computer crime was within the state and had the consequences only within the state. This could be the case of a when the computer is used as the object of the crime, as we saw initially. So if there was a theft of hardware at a specific computer store, for example, then the state court would have jurisdiction over it. But in cases in which the computer is used as either the subject or an instrument, it is mostly likely, not always, but most likely that federal courts will have jurisdiction. Moving on, we will look now at the main federal statutes that are associated with computer crimes, and then detailing some of the crimes they deal with. So the first act we'll look into is the Computer Fraud and Abuse Act, also known as the CFAA. And this act mainly deals with the prohibition of accessing a computer without authorization, so unauthorized access, to obtain information that could harm the government of the USA or that could benefit any foreign country. So this statute is mainly related to this felony, to this type of criminal conduct. The other one is the Communications Decency Act, and also the Protect Act. And these two, they are related to child pornography. So remember, child pornography is a computer crime in which the computer is used as an instrument, and they will be dealt with through this Communications Decency Act and also the Protect Act. There's also the CAN-SPAM Act, and this one deals with unsolicited email. So there are several. There's initially a definition of what a spam is, and it would be considered a spam if there are multiple emails, such as more than 100 emails during a 24-hour period, or 1,000 emails during a 30-day period, or more than 10,000 emails during 1 year. So whoever sent such quantities will be regarded as having sent spams, unsolicited emails, and there will be penalties through this CAN-SPAM Act. The Safe Web Act is an act that mainly gives powers to the Federal Trade Commission, the FTC, to enforce the CAN-SPAM Act. So we know that criminal law, if they are not enforced, they are actually not effective. They may even become useless. So this Safe Web Act is very important, so that not only the Department of Justice in the US has powers to enforce the CAN-SPAM Act, but also the FTC that is a lot involved in business. And then we have the Copyright Act, which we have already looked into, and the Digital Millennium Copyright Act. And both of those acts, they prescribe or they have civil and criminal liability for copyright infringement. So copyright infringement not only attracts civil liability, so possibility to have to pay compensation for infringement, but also criminal liability. So the possibility to have to pay fines and even to spend some time in prison. So this will be in the Copyright Act and also in the Digital Millennium Copyright Act. Moving on, we have the Electronic Communications Privacy Act, the ECPA, and this one is more related to the surveillance of electronic communications. So it is illegal to intercept electronic communications transmissions, and there will be also prescriptions for crimes such as hacking, which is intercepting or entering or having unauthorized access. So the ECPA is mostly related to crimes in which the computer is a subject to the crime. And then identity theft is in the US Code, Title 18. And what is identity theft? It is obtaining details of a name, credit card details to commit crimes. So using someone else's details, identity details, personal documents, credit cards, etc., to commit a crime. So it is in the Title 18 of the US Code. And there's also the Federal Wiretap Act, which will prohibit any interception of wire, oral, or electronic communication. Again, unless there's a warrant. So whenever there's a warrant, then such interception may be legal. If not, government officials cannot intercept, nor can any other person do this. Okay, so now looking at the challenges, very briefly, the challenges of prosecuting computer crimes, investigating and prosecuting. So it's usually really difficult to find the true identity of criminals, but there's a lot of cooperation among agencies, like Canadian agencies and US agencies. They cooperate a lot. During this Cyberware Aware Month held at BCAT, there was this cybercrime person, a person who works with cybercrimes in the RCMP, and she was delivering a lecture, and she told us that if, for example, money is withdrawn from your account electronically, And if you inform the authorities right away, in up to 72 hours, their chances are higher through the several agencies and even private institutions, banks, to stop this money, this amount, and bring it back to you. So from the moment the withdrawal of money happened until 72 hours, chances are higher to have the money back. Over 72 hours, then things get more complicated and chances are lower for the money to be back. So it's the cooperation among agencies, institutions, private, public. It is very important here. And the concept of extradition. So extradition is when an accused or someone that was convicted of a crime is in a different country. So the country in which the accused was convicted may request that other country to surrender the accused or the convicted, the criminal, to the country they were convicted. This usually happens when countries have a bilateral or multilateral agreement in which they act with reciprocity. So if one country does, the other will also do it. But there's one thing that is interesting here and relevant, is that usually nationals of a country will not be extradited. So let's say a foreigner comes to Canada, commits a crime, goes back to their home country, and then they are prosecuted here in Canada, they are convicted here in Canada. Canada requests extradition of this convicted criminal, but chances are very low this extradition will take place because the criminal is in their home country and nationals are usually not surrendered to another country. What may happen is that that country may decide to execute the criminal punishment. So that country may arrest the criminal and then send them to prison time, jail time, if it is the case. And to finish this chapter, there's this CCIPS, the Computer Crime and Intellectual Property section that works with the U.S. Department of Justice, is one part of the U.S. Department of Justice, and their main job is to prevent, investigate, and eventually prosecute computer crimes. So they will cooperate with other agencies, FBI, police agencies of other countries, Interpol, trying to investigate and prosecute accused or criminals related to computer crimes. So that's what I wanted to share with you with regards to cybercrimes. Again, we looked at the categories of computer crimes, in which computer may be the object of a crime, the subject of a crime, or an instrument to commit a traditional crime. And then we discussed a little bit about the Latin expressions and the requirements for criminal activities, which are the actus reus and the mens rea. So the actus reus mean the act, the objective part, the wrongdoing, and the mens rea meaning the guilty mind, the intention to commit that criminal activity. We looked at the Fourth Amendment, which prohibits search and seizure unless there's a warrant, and in case such prohibition is not respected. We also saw the exclusionary rule, the fruit of the poisonous tree, so that illegal evidence may be excluded from prosecution. And we looked at jurisdiction. Mainly computer crimes are prosecuted via federal courts in the US, and the federal government is the one, the House of Representatives and the Senate will be the ones passing legislation for computer crimes, mainly. We looked at some federal statutes and their crimes, the crimes that are related with them, and we just ended talking briefly about the challenges in preventing, investigating, and prosecuting cybercrimes. Thank you, and we'll be back with more wrongdoing in Chapter 8. Bye now.